This is Gnostic Media Research and Publishing's podcast episode number 160. I'm your host, Jan Irvin. This episode is an interview with Freeman, Burt, and Clint Richardson titled From Weather Modification to Mortgages, Notes, and Foreclosures. And this is actually their second time together on this, so this will be part 2. And is being released today, Wednesday, April 3, 2013. My interview with Clint and Burt was recorded on Tuesday, April 2nd, 2013. Freeman Burt is a man who lives under the belief that all people are born free and that no one can be required to become someone's servant. He's almost 50 years old and has been studying the elements of freedom for about 20 years. Most of his gain in comprehension came when he fully accepted the fact that all legal relations require our consent. From that point of view, it became easier to accept the truth that the legal law is correct. He is not claiming that it is right or moral, just that it is correct in its application. The more time he spent reading the actual statutes, codes, and ordinances, and legal dictionaries, the more he's learning that we are in fact free and that we volunteer into servitude. Freedom is a voyage with no predetermined destination because such destination does not exist. As long as there are slaves in this world, we ourselves can never be free. And you can check out Freeman Burt at Don't Consent 83 at YouTube and also at www.onlyfreemen.com. And Clint Richardson, of course, is back for, his 7th or 8th time now, so I will spare the long introduction for him. I think you can all check out one of the earlier episodes, not the last one, though, because I skipped at that one, too. And let's see here. Again, we've got the new Gnostic Media bookmarks with the fallacies on the back for each book order, and those are up on the website for sale. And donations. This episode is dedicated to David, Matthew, Jeremy, Evo, Michael, Samuel, Christopher, Scott, Tad, Janet, Max, Paul, and John. And we do our best to provide just about everything here for free, so your donations and website purchases are greatly appreciated. This show is run on donations and our website sales and is not corporate media, but independent media in the truest sense of the words. By donating or ordering one of the books, a DVD, the SWR archives, a t-shirt, or getting a membership to the website for the older podcast archives, you help to continue this programming, or unprogramming, I should say. We greatly appreciate your support. And again, the first 4 years of the Gnostic Media podcast are up on the store page, so if you'd like to order one of those, we'll get that right out to you. The views expressed by the authors and guests of this unprogram are their own and are not necessarily those held by myself, the host, or Gnostic Media. You can check out the website at www.gnosticmedia.com. That's GNOSTIC media.com. You can reach me directly at contact@gnosticmedia.com or through the web form on the website. Thanks for listening and thank you for your support. And here is my interview with Clint Richardson and Freeman Burt. From weather modification to mortgages, notes, and foreclosures. This is an important one, folks. Enjoy.
Did you get a chance to look at that thing that I sent you there?
I did. I didn't finish all of it, but I read...
okay, just kind of glanced through it.
Oops. What's that?
Yeah, I just glanced through it. Yeah, that's all what I really wanted. Just kind of to get a feel, because I was talking to Clint and telling him that the U.S. attorneys actually operate as though they're working under the laws of Guam. I wanted him to see that. So I sent you some stuff there, Clint. I don't think you had a chance to look at it.
Through internet?
Yeah, on the Skype box. You are a busy senor.
We're all busy.
Well, I'll tell you, the court out in... come on, computer. The court out in California just stated that Stockton is full steam ahead to go bankrupt. And Stockton is what I was basing my whole book around. So I've got this massive, basically tearing apart the entire city CAFR from line to line. And so now I'm just going to go ahead and release it at least that part of it, so that and show that Stockton has billions of dollars that it's not showing people, and that it hasn't filed a CAFR for at least a year, and hopefully that will be one of the things that will
deny it.
Well, and hopefully I'm going to try to get someone there to get Walter in there and and do his thing, do an audit and doing all that stuff, and we'll see. Because it's like the perfect opportunity, because Stockton is huge. I mean, it's a big government.
Well,
right.
You know that during a bankruptcy hearing, anyone can bring in information that could delay or deny the bankruptcy. You know that, right?
I don't know that, actually.
Yeah.
Oh, maybe I should go in there.
Yeah, that's what I'm saying. You could bring that information in, and the trustee would actually have to look at it.
Just so you guys know, I'm recording this, so we get all this good stuff on Stockton for the show.
Okay.
Well, yeah, I can't. I mean, I'm just amazed, and I went through and I found all the little secrets and all the little things, and I just went to every corporation and association and everything else and explained it all. And I'm kind of glad I did. And like I said, I was reserving it for a book, but I guess it's going to be now. It's just going to be another post.
Well, life's interesting turns.
Yeah.
So, what subject are we going to launch ourselves on?
Well, if you don't mind, Jan and Burt, I kind of want to start off with something a little off topic, which is just that last post that I did on chemtrails, and it has a lot to do with what we're talking about. It's just
you know what? I keep forgetting to read that. Thanks for reminding me again.
Yeah. Well, it's I can't tell you. I think it's absolutely paramount, actually. I can't say enough that I finally got it on, out of my mind and onto paper. So I'd like to start off with that, if you don't mind, just to get people to direct to it.
Please. Well, just like last time, we're going to let you pretty much head this show.
All right. Okay. Still trying to pull up your thing. I don't have Microsoft Word. Oh, there it goes. All right. As a peaceful man. So what am I looking at, Burt?
Oh, well, it's just going to be, if you didn't have a chance to look at it, we'll just refer to it as the subject pops up. I just put in here some actual court cases and some statutes that I think people will find very interesting about the United States court and United States court system and attorneys for the government, etc. Some of the stuff that I was talking to you about the other day, also about how the Guam relates to attorneys, U.S. attorneys. That you were asking me, like, what do you mean Guam? What does Guam have to do with the U.S. attorneys? And I was like, well, the statute ties them to Guam. So anyway, we can refer to that later, though.
All right. Well, I guess I think I'm ready.
We'll go for it.
John, you going to do you going to do an interview or an introduction?
I suppose I could if I would turn my microphone on. But, yeah, we're back here with Clint Richardson and Freeman Burt, and I think, Clint, you today wanted to talk about mortgages, notes, and foreclosures, if I'm correct on that, and what you believe to be foundation to law.
More specifically, I'd like Burt to talk about it because he's getting so advanced in these days.
Yes, I stand corrected. So, and we were with both Clint and Burt last time, and our last talk was the court clerk and the court of record, and we're going to be continuing with more on that, and I've had a number of people excited to hear more from you today, Burt, so let's dive right in.
All right, well, if you all don't mind, I just wanted to talk real quick about it's kind of off topic, but I just wanted to talk real quick about my last post, and it actually has a lot to do with what Burt and I have been discovering mutually over the years at this point, huh?
Yes, sir.
Yeah, it's been floating in my mind for quite some time, and what I wanted to do is I keep hearing all these interviews on chemtrails, geoengineering, whatever we're calling it nowadays, and as I understand the law and I understand what's happening in the country, I finally came to figure out that everything that's happening is simply done so on the behalf of or with the informed consent of the people, and that's all people. So when you're talking about spraying something over the sky or geoengineering or altering the environment, as is posted in the U.S. Code on Biological Weapons, it specifically says that informed consent must be gained by all people or all victims, whatever we're calling them, all subjects, I think is what the official term in the U.S. Code is. And after putting all these pieces together and discovering the word consent in a deep, spiritual way, and understanding that basically everything that we do as citizens of the United States is on a voluntary structure. In other words, we talk a lot about creating a voluntary society, and yet we don't realize that everything that's happening in our society, in our government, is actually voluntary. In other words, we are fooled as citizens. We are fooled into granting our silence, which in effect is consent. In other words, silence is consent. And so what we found...
let me just interrupt you real quick there, Clint. So what about us who haven't been silent on this topic and voicing that we do not consent? How are we therefore consenting?
That is absolutely the point, and I'm going to get to that real quick. What I found, because remember, silence is consent. When I say the word silence, I don't mean verbally just silent, you didn't say anything, you didn't do anything, you didn't try to stop it. That's not what I'm saying. See, that's all happening in the artificial world. Okay, everything, as far as government is concerned, everything outside of the legal realm or the legal language, the official legal document, the demand, everything else doesn't matter. So you can call your congressman, you can email those guys, you can send them letters, you can scream from the top of your lungs, please, please, please don't, hit us with biological weapons, don't spray our skies, don't do all these things. But see, that is still not in the legal realm. To be in the legal realm, you actually have to do it in a specific fashion, which we sort of talked about last week with the court clerk and the court of record. And so what...
So are you telling me, Clint, that if I want to stop geoengineering in the San Bernardino Mountains, that I just go down to the San Bernardino Court of Record and file a thing with the court clerk there that I do not approve of geoengineering and spraying on me, so therefore stop, and then that's it?
Well, that's not it, actually. But that is the first step. The first step, and what I envision, is getting a global grid, or at least a national grid of thousands and thousands of people who do just that, who go to their local office and submit basically a non-consent form. In other words, I withdraw any form of presumed consent, and I do not have informed consent, as is required by your own codes, which is listed here. And I listed all of the statutes in this post. It's a very long post, but very, very, very important. Now, once you get enough people, even one person technically should be enough, but once you get enough people that have submitted a demand that their consent is withdrawn and that the spraying stop, the geoengineering stop. In other words, you can no longer spray the skies on my behalf. As my representative, I do not give you consent. And again, right there in the U.S. Code, and that's in the article, it specifically says that in order for this to go, in order for the deleterious alteration of the environment to happen, there must be informed consent. And this is, I'm finding, is across the board with everything that happens. So, now that we have a record. See, this is the important step that I think everybody has missing because no one seems to have the solution. Well, the solution is to end a contract. That's the legal definition of the word solution. Everybody asks for solution, and yet no one knows what the word solution actually means. Look it up. It means to end a contract, to withdraw your agreement or your permission to do something, to end a contract or to satisfy it with by paying off the debt. Okay, that is.
Let me add 2 words. To withdraw your participation.
Yes, your voluntary participation. In other words, your consent. So, now that you have these however many people, and this is something that everybody can do, even the most cowardly lions out there, from the most cowardly lions to the bravest of us out there, we can all simply send a legal document, 1 or 2 pages, signed and confirmed by being certified mail and being notarized, which is basically court outside of court. And we put that on the court of record, as we said before. Now, this is the important step, because you can't stop there. Because at this point, when you have this many people in this grid of non-consent across the country, and keep in mind, technically this could be used for anything, including the illegal occupation of Iraq. If I don't consent to it, and they're doing it with my consent, my informed consent, then technically they are breaking the law as soon as I file that form of non-consent. Now, thousands of people have suddenly introduced to government on the court of record, in other words, the highest court of the land, that their consent is not given, nor is informed consent accepted or voluntarily given the permission. All right? So we've just withdrawn consent individually, not as a group, not as a class action lawsuit, not as anything but our own individual selves. Men and female men, women have done this, okay? They're not doing it with a lawyer. They're not doing it with an attorney. They're doing it by themselves. Now, all of a sudden, we have a government who has a decision to make. Either they keep spraying without the consent of the people, the informed consent, because now the people have withdrawn that consent, or it can stop spraying. Now, if it continues to spray, we actually now have the only case in history where the people finally woke up to how to stop this by saying I don't consent on the legal record, on the court of record. And now we can prove, and this is the most important part, now we have a proof of claim that the government is breaking its own law. You see, this is the scheme that's been working in my head for a long time now, and I finally got it out, and I finally wrote it down, and just wanted to draw attention to that because the power, it turns out, in my research, and I think in Burt would concur to this, the power is not with the people, because the people is a body politic. In other words, the people act as one entity who are represented by,
so
528.
What you're saying, Clint, is it's not the people, it's Clint and Burt and John,
exactly,
etc.
because right now we're in a group herd mentality, and everything that's happening is because we all consent at one time to having a representative consent for us. Okay, the only people, real people in America, technically are operatives because we do not have a voice. Okay, we don't vote for president. We talked about that. The Electoral College votes for president. The people they vote, but they do not elect the president. This goes all across the board, and we have representatives that are doing this for us. So what we have to do is we have to step outside of this group mentality, and we have to take the responsibility as individual men and women, and we need to submit our forms, our personal non-consent. That way there is no more group.
Yeah, let me jump in and clarify something that you're saying. One point that's very important in what Clint is saying about basically entering something into the record. Once you have something on black and white on paper, either as an affidavit or notarized or whatever shape form you make it, and you give someone a notice, you're now putting them on notice. So if they continue to either attempt to represent you in that capacity, which Clint mentions a citizen of the United States, if you tell them, I do not authorize you to represent me in that capacity, and they continue to act like they're representing you in that capacity, that's actually fraud.
And for the first time, you can actually prove that it's fraud because you have that claim, that demand. That's the only way to do it.
Couldn't we stop the CAFR and the way that our money is taken and invested and not given back to the public? Couldn't we use the same sort of thing? I do not consent to this CAFR to stop that.
Well, technically, I mean, the CAFR is just a system of reporting. It's not really a thing as much as it is just a physical, audited report. Let me re-ask that. Couldn't we block the hidden investment of our money and the non-return of those funds into these investments by writing something down?
Not your money.
Technically, again, you would, in your letter of non-consent, you would simply, and again, I believe that once we get this organized, again, an organization without actually joining an organization, in other words, a few people like Burt, myself, and whoever else, even some attorneys, as long as they're not acting as officers of the court, it's going to be hard for me to trust any attorney. But if you get the letter and you get it written in the proper way, technically, in my opinion, and again, this is in the opinion stage and a lot of research, in my opinion, this will work. Technically, it is supposed to work for anything. So again, war, emergency executive orders, anything you can think of is all based on the informed consent of the people. Now,
Okay.
the one thing I didn't mention, and I really want to get this across to you so you understand what informed consent actually means, okay? Because it's not just the U.S. code that allows all this to happen and regulates it. It's not just the codes that say every darn one that does it has to put a permit or get a permit from one of the local government. Okay, these are all the statutes that allow it to happen. But what the most important part of this whole thing is how government gets informed consent. And that's the real nasty trick of it all, because here's what it does. See, a friend of mine, for some reason, he likes to go through the public notice section because he likes to see where, everything that government does, basically, it puts the oldest form of notice is the newspaper. So in the public notice section of the newspaper is where you're going to find every golden thing that's happening in government. When they want to raise a bond, they have to list it as a public legal notice that they're going to have a hearing or a public meeting about doing this. So what do when they want to spray the skies or create snow, any kind of weather modification? Believe it or not, they put a public notice in every county newspaper in Utah or in California.
Okay. Let me jump in real quick, because there's a very important point about what Clint is saying right there. That act of actually putting the notice in a newspaper is 110% pure common law. Okay, what they're doing is they're covering their butts so that they cannot be, basically, no one can come against them under any kind of a common law position, because they did their best to notify everyone. Now, the other important part about what Clint is saying right there is that by putting it in a newspaper, they're actually accessing two groups. Number one, they're accessing the public, which is the members of their body politic, and they're also accessing the general public. And the general public includes people who are not members of the body politic.
Right. And so what you've done by doing this, because how else can you possibly get the entire public to be informed but by using the oldest medium of information, which is the newspaper? So if you do a search, for instance, if you search for the one in Utah, which went in every county, said Utah Notice of Intent, Weather Modification. So you have a notice to the public of the intent of government to allow weather modification. That was the title of this particular...
And so what you're saying, Clint, is that the government published that they wanted to do weather modification and geoengineering, and it just went right by everybody because they don't read the damn newspaper anymore.
Absolutely.
And nobody showed up at the hearing, and they hammered the gavel down and said spray.
Abso-freaking-lutely. That is exactly what happens, and it happens with every single aspect of everything that government is doing. They have to give informed consent, and the way that they do that is to give a legal notice in the newspaper.
Okay, now let me jump in here. Now, if they are able to do this, does this mean that you are also able to do this? Of course.
Well, yeah.
We can also give them notice through a newspaper.
As far as weather modification, absolutely not. You are not allowed to do it. Only government-approved corporations. And
no, that's not what I'm saying. I'm saying that we can give them notice of something that we are trying to put them on notice of.
Right, but for us to do it, we wouldn't do it. We could do it in the newspaper, and in fact, that is a viable solution. You can do that, though I believe that doing it in the court of record would be a much more viable solution, not only in the local court of record. I'm talking the county, the state, the federal government, and if we wanted to be so bold, we could even do it with the United Nations, since they seem to consider us all members or citizens of it and want to replace our Constitution with their Notice of Human Rights or whatever it's called. So, I mean, technically...
Well, let me just give you one example, because it's something that I'm doing along those lines. In another case, I'm sending it out tomorrow, actually, a counterclaim that I'm doing, and it's going to be filed in the court of record. But what we're also going to do is publish the counterclaim in a local newspaper, so that we can then say that the people of the state of Florida, because that's where this is, and the people of the particular county have been lawfully notified.
There you go.
So
I mean, it really is the basis of everything that's happening. Is this notification process, the notice of intent? Let me just read this so that you get an idea here. And again, if you search for this in your city, basically notice of intent, weather modification, I typed in Utah, and this is what came up: North American Weather Consultants. Right here in good old Sandy, Utah, which is real close to me, so it's a corporation, a contractor licensed by Utah Division of Water Resources, so it's licensed with the state of Utah, intends to conduct weather modification programs in Utah to increase precipitation with the following potential sponsors. It goes on to list every Utah Water Resource Development Corporation and every county, which are corporations, municipal corporations. And then at the end, it states, and county, so the whole state has been put on notice now, has been given informed consent, or we gave them informed consent by not responding to this. And then at the end it says, and this is the most important part, it says the operations may be conducted during portions of the period from October 15th, 2012 to May 31st, 2013. Weather modification operations will be conducted using ground-based silver iodide nuclei generators. Now that is to create snow. We all know about that, but what we don't know is what silver iodide is, and I go into that because it's actually an antiseptic, meaning it actually kills anything. I mean, you used to put silver coins in water to kill whatever was in the water, so it would be drinkable. But then at the very end, it sneaks in this very, very important sentence. It says, limited aircraft seeding may be conducted for research purposes. Okay, it goes on to give the contact information, Utah Division of Water Sources, and North American Weather Consultants. So, I mean, again, this is... There's another one that says Emory Water Conservancy District intends to conduct weather modification programs in Utah to increase precipitation. Da-da-da-da-da. So, again, I can't stress this enough. This is literally, even though nobody in this town or nobody in any other county probably actually read this and gave it a second thought, this was literally the thing that gave government informed consent of all people, because nobody responded to this by saying, no, you do not have my individual consent.
Let me ask you something, Clint. What if we went down to the Court of Records and filed something that states, my silence is no longer my consent?
Well, I mean, I'm not opposed to anything at this point. I don't know if that would be a blanket thing that would work.
Sure. I mean, what I'm getting at is like, you could even put something in there that says, I must be contacted directly and personally with anything that's, requires my consent. And, my silence is not my statement of consent from here forth, in any way whatsoever.
So, Jan, here's the point. I mean, and that's actually a very good question, because what you've done now, again, you haven't really limited them from doing anything. What you've done is you've entered it into the record that in order for them to continue to do anything, they actually have to notify you personally. And if they don't, then they are acting illegally. And now you have, again, proof of claim on the public record that they are operating without the consent of the public. In other words, they're breaking their own written law. So the important point, of course, is to submit the letter in the first place, but more importantly, it's to have that on the record, because otherwise there is no proof that they are breaking any law. Everything government does, folks, everything is legal as long as we don't say anything about it, as long as we just are silent. And when I say silent, again, I don't mean holding up a sign, or I mean we must use the proper legal recourse to stop it. That is what ending silence means.
Use the force, Luke.
Use the force.
Let me clarify something. When we're talking about the court of record, it doesn't mean a place where you can go and file whatever you want into the record. The place where you can actually file something into the record is actually the county recorder's office.
Yes.
Okay, that's the public records office. Okay, the court of record, the record in that term simply means that the court clerk is maintaining a record of the decisions that happened in that particular case. Okay, but it's not a place where you can just go and file.
Right. We should clarify that what we're doing is we're entering that into the court of record, but we're actually sending these letters or hand delivering them to the offices of intent. In other words, you have to get it on record that they received it, and when you do that through the court of record,
which is the office you take it to?
Okay,
Burt?
hold on. Let me clarify this. The only thing that you can record in the court of record is an actual case. So you can only record in there would be if you either are filing a counterclaim or you're actually filing a suit. Okay, which means you're suing someone. If you're going to file a public record, you would do it in the county public records office.
And this is what I'm asking for people right now is this can only happen, just as you heard, if Burt, myself, and some other legal minds out there that are sincerely looking to stop this, not in a for-profit way, not by using the court as their little tool to be an attorney and make money off it. This is not a for-profit entity. We need to get a group together that can create the very system that we're talking about, get the right court, get it signed, get it notarized, and then create that document so that everybody can download that with a set of instructions on how to do this. That is what I'm seeking, and that is really the point of me bringing this all up in the first place. You can read all about it on my blog. It's called The Only Way We Can Stop Geoengineering. But the important part is that I can't do it. You can't do it. He can't do it. We have to get a group together, and I'm hoping that someone out there can, organize this, create a website, hopefully someone with some clout that already has a chemtrail following that's not too out there. And, really, I don't see any other option because they're really, without short of violence.
To reach out to Michael Murphy?
I was trying his partner, actually, but they were trying to get me to talk to his attorney, and I'm just don't want to talk to an attorney, an officer of the court. So I'd like to get them involved, but I'm a little wary of who does get involved, because I want to feel like they're actually sincere and they're actually doing this not to sell DVDs or not to do whatever. But I think that Dane Wigginton, which is his partner, is the man to really go to. But again, I tried to contact him, and I had a friend finally get his attorney, but we haven't had any contact at this point. So if I can get some people to support this and go through, I think that we could possibly create a very, very vicious force of people. And again, this doesn't just have to apply to weather modification. Choose your goal. I mean, really, technically, anything on a national or international level that's happening requires the full consent of all people. So, choose your battle.
Let me add a little bit to this, because basically, what Clint is saying is that each of us has the power to stop any corporation. It really doesn't matter how big it is. Now, if I was to ask someone, would a fish or a grasshopper or a mouse have the power to stop a corporation? And the truth is yes. And the mouse can't even speak, can't even file a piece of paper. But we can all think of major projects that were stopped because some little mouse or grasshopper was going to be injured by that particular project. In Colorado, they stopped a huge water called Two Forks or Three Forks, whatever they were going to do out here. They were going to create these huge dams, and because of some trout or some fish, they weren't able to do it because the trout was going to be injured. Now, if some fish is going to be injured and you can use that to stop a multi-billion-dollar project, can't you stop it for one or two people that are being injured? Of course you can. But those one or two people have to come and file their case, and it has to be based on the fact that they are either being injured or there's a high likelihood that they're going to be injured by whatever it is that's happening. And we have the power to do that, and we don't need attorneys. We don't need any of these things to do it. We just need to learn the basics on how to go about presenting our cases in the proper court.
And I've heard a couple people say, you have to do it in a traditional way. You have to follow the standards and practices and best practices that are presented in this group and this group. And I'm here to tell you, folks, we need to avoid that type of thought, and we need to follow basically the letter of the law. We have to act as individuals and not fall into the trap of being a group, because once you're part of a group, your individual voice is gone. And I guess you could use the example of, if you're suing a pharmaceutical company because it's killing people, imagine that. If you're the pharmaceutical company, would you rather have 100 different people suing you individually with individually different juries all deciding on the merits and value of the case? Or would you rather have one class action lawsuit where everybody's voice is one voice, and it's basically the only people who ever make money off it are the attorneys who represent the case, and they're in it, they're officers of the court, not really in it for the people, they're in it for their own pockets? What would you rather have as a corporation or a government? Would you rather have thousands or millions of individual voices complaining, or would you rather have one big voice that does absolutely nothing? Well, if it was me, I'd rather have a big class action.
Yeah, I mean, just think about that. Think about the wealthiest of all the corporations, which would be the banks, right? So imagine something like Mellon Bank, $23 trillion in assets. Now, imagine 1 million people, just 1 million people, each one filing a lawsuit against Mellon Bank. Oh my God! They would break down the bank. The bank would go bankrupt.
Just consider the attorney fees alone for them. I mean, it would just be...
They wouldn't have enough attorneys to go around.
That's what I'm saying. The real power of the people is not as a body politic, but it is in fact escaping that trap and attacking individually. That is where the power lies, and it's a concept that really has escaped me for most of my life, and you can see it. You can see the fruition of how powerful the concept of groupthink is, because nothing is getting done. Everybody's complaining and nobody is getting anything solved. And that's because the solution, again, the legal solution, is completely eluding people because they're in groupthink mode.
Are you saying that the solution isn't to stand on the corner with a bunch of people with signs?
That's my personal opinion. Again, I like to use the example of, hey, let's go picket the Federal Reserve. Oh, well, hang on a second. I'm going to go spend a Federal Reserve note to buy a soda.
Yeah.
Hold on. Right? I mean, the whole thing is ridiculous when you think about it. And personally, Jan, I think you'll agree with me that most of the movements out there are either controlled or co-opted.
Sure, the quote-unquote truth movement that doesn't even remove the fallacies from their own thinking to make sure that they're not following fallacies or lies and being misled, which is
absolutely
the first absolute step in a truth movement. You have to have critical thinking so that you know who your enemy is, that you know how to fact-check things and what you're dealing with.
And this is basically, you could consider this, to use the movie reference, which I actually quite enjoy using it as a reference nowadays, is to wake up from the Matrix. I was talking to Burt about this. If you realize, suddenly sit back and you realize that everything, again, we talk, Larkin Rose and all those guys, who I completely admire and respect. We're all, we talk about, we really need to create a voluntary society. And again, we're in a voluntary society. We just don't realize. What you're saying is we need to apply it by constantly keeping a subscription for the newspaper and going through the public notices and running down to the court. What we're doing is volunteering on a continual basis. What we need to do is withdraw the volunteerism that we're getting.
So how do we withdraw? Do we do it like I said a minute ago, going down and filling something out that says my silence is no longer consent?
Well, see, the good thing about doing something like that is, again, you're getting it in the record. You're getting it to a point where you can actually use it in a court of law. So it can't, things can't be used against you if you never consented to them in the first place. So that's the idea that I'm been tossing around my head. Now, whether I'm correct, I hope so. But the only way I can know is if people start actually helping me to figure this all out. Because I'm just one guy. Obviously, I'm missing some pieces that Burt is filling in and you're filling in. So it's a matter of getting the right minds together to really hash it out. And I think that, I guess the point is, I don't think there's any other way. I can't see any other legal way of stopping it. In other words, there is no other, that this is it. It says it right in their own codes that they need our consent. Well, let's withdraw it.
Well, let me jump in here for a second. Because Jan, you're saying, is it all that we have to do is just file a piece of paper? Is it all that we have to do is just make a declaration?
No.
And Clint and I have gone around and around in this because he's a very good, he plays a good devil's advocate with me. And he questions a lot of the stuff the conclusions that I make. And he forces me sometimes to go out of my way and prove it. But that's what keeps me in check. But this is what I'm finding out, because in this movement of freedom, people get caught up in, do I call myself Freeman Burt? Do I call myself God's Burt? Do I call myself whatever? It really doesn't matter what you call yourself. Do I fill out some kind of a oath paper, some kind of affirmation, some kind of declaration so that the whole world knows who I am? That doesn't really seem to matter. Now, one way to look at this is if you have a football game going on, whatever the problem is between Team A and Team B is decided by the referee. So if the referee is corrupt, if the referee cannot give a true neutral decision, then basically one team is screwed if the other team controls the referee. And the courts are the referee. If we cannot have a neutral court, if we cannot have a lawful court, we're screwed. Because the court is the one that is supposed to keep people civilized. Without a neutral referee, then the only other way for us to keep a corporation in check is to go over there and burn everything that they have. Burn it down. Go there with pitchforks and, take all the CEOs and put them under our pitchforks. So we have to have a court that is accessible to us. When the court is not accessible to us, we're going to have revolution. Okay? So the answer, the way I'm seeing it now, and the further I'm moving down this thing, is we have to be able to use the court for our benefit. And our benefit doesn't mean that the court is always going to rule in our favor. Our benefit means that the court has to be able to act neutrally and follow the law. And the law is not necessarily the legal law. The legal law is nothing more than procedures. The law is the law of the land, which is God's law. When the basic law is violated, nothing else matters. And that's what I'm finding out, that is actually the bottom line of the bottom line.
See, and along with that, like I said, if you sit back and you think about everything that you've ever signed, everything that you've ever agreed to, I've always said, well, it's a contract. And at this point, you can still call it a contract, but if only one person signs an agreement, well, then is it a contract between two parties, or is it just an agreement by one person to follow a certain set of guidelines that are printed on a unilateral contract? Well, technically, if I sign a contract that's a unilateral contract, say with Microsoft or with my driver's license, the question I have to ask is, maybe Burt can answer this. Well, Burt, if I sign my driver's license, card, whatever, how does government sign? Can government sign anything?
No, because they're a fictional entity. That's why any agreement that you enter with a corporation, you're always the only one who signs.
So
no one ever countersigns.
I'm actually acting as the surety for my person. In other words, my artificial person. And the surety cannot be disconnected with the signature necessarily. But what I'm doing is I'm signing as a in commerce. But the question is, who is government assigned to? Government is not a man. So how can you enter into a binding contract with a fictional thing?
Yeah,
you can't. So everything that we do is voluntary. In other words, everything that we sign is nothing more than agreement to follow rules.
Exactly.
And that, if you take it back to the Matrix, which again I hate to use it, but that is really when you wake up to what the Matrix is, you realize that it's just a blinding wall of what we think are rules, regulations, and contractual obligations. But in reality, if we're the only ones signing this contractual obligation, which it turns out is just basically me agreeing to a set of rules and me agreeing to an arbitration and me agreeing to a punishment without any agreement from the other side, as long as they're providing the so-called service at the barrel of a gun. So technically, waking up to the Matrix is really, how do you change the Matrix? You change the content of the agreement. But who does government have the power to stop you from altering an agreement that you made, that you signed, but they didn't? This is the question I wanted to start out with Burt. How, is it possible? Am I off in law land here to say that technically, if everything is agreement and if I'm the only signer of that agreement, am I the one person or the one man that can actually go in and alter that contract, that agreement? Because government seems like wouldn't be able to, because they're not a signatory. So am I making sense?
Well, and that's, I'm in the process of proving exactly what you're talking about, because there's one feller that I'm helping, and he had a deed of trust, a note, which anyone that has ever gotten into a house mortgage knows that you're the only one, in fact, that signs the note, and you're the only one that signs the deed of trust or the mortgage agreement or whatever document is associated with the so-called property that you're buying. So what we are actually doing is we redid one of his deed of trust, and we changed all the original terms in there to favor him. And he re-signed it and sent it to the company, telling them that since he's the only one that is authorized to authorize this document or this paper, he's now reauthorizing himself to change it and make changes that no longer are beneficial to him.
Okay, so what are some of the changes that he's making?
How about zero interest?
That's a good change.
How about zero monthly payment?
How about zero principal?
Yeah, how about zero principal?
How about zeroization is basically amortization is what we're talking about. So you're basically
nullifying the original contract.
Well, you're not.
If you want to call it a contract,
you're not nullifying, though. You're actually continuing the contract. You're just making, as the authorized signator, you're making changes.
Yeah. What does the bank or the mortgage company say when they get one of these? And does somebody call you or the person and have anything to say, or are they just in awe? What is the response when something like that happens?
Well, what's the response that you hope happens?
Well, this is a key. Whenever you're communicating with these people, whenever you communicate with these people, you got to put everything in a term of time. You have to give them time to respond. And the way I operate with these people is I'm providing them with 21 business days. So basically It comes out to be 30 days. So I give them 30 days to respond to whatever it is that I'm sending them. And I'm telling them if they don't respond within 30 days, then I'm going to take that as them agreeing with it. Okay,
which would go back to getting a default
judgment. Yeah. So now they're agreeing with me. So now they would have to come back and say, "Oh no, we in fact didn't agree. It was our error. We didn't receive the paper, blah blah blah." So that's why you send everything registered, so you have a record that they in fact received it. And then you can follow up after the 21 days, another notice letting them know that, hey, I sent you this. Now I'm giving you for the last time another 10 days for you to respond. And this is basically a notice of default. I'm giving you a notice of default, letting you know that you acquiesce to my first notice. Now, after this 10 days, this actually becomes a default notice that I can execute against you. And technically, that's all you need to take to the court of record as evidence and demand it be executed basically through the sheriff.
That's an interesting thing that you just schooled me on, is the sheriff thing. I did an extensive study on my sheriff, because the sheriff here, my article was the sheriff who sold his county because the state created a corporation called the Unified Police District, and all the sheriff's deputies and the sheriff basically transferred all the property, transferred over to this district, and there is no longer a sheriff's department. And what was interesting about it, and I didn't understand it at the time until I talked to Burt, I think yesterday, is that the sheriff is acting as CEO, Chief Executive Officer of this private corporation. It's actually a special district, financing district, and it's called the Unified Police Department district, actually. And the only so he sort of wears two hats. He wears.
Hey, somebody keeps bumping the mic there. Please be careful or mute your mic.
He wears the hat of the elected sheriff, and he wears the alternative hat of being the CEO of this corporation, of which the board of directors is the mayor and the councilman of each city that gets involved with this unified district, which basically takes away all jurisdictional borders. What I didn't understand at the time is that the only people that didn't transfer over into this UPD, this private association, was the sheriff's deputies that control or the bailiffs that are in the court system. And Burt, why don't you explain that? Because I never understood why people would say, and I don't think most people understand it when they say it themselves, because I said it and I didn't understand it. Why is it that the sheriff is literally the law of the land when it comes to the court system?
Oh, hold on. I had to turn on my mic. Well, because the sheriffs work directly with the court clerk. So when the court clerk is going to enforce anything from the court, the clerk doesn't have guns. They don't have, the muscle. The muscle for the court clerk is, in fact, the sheriff.
So if you're the court, if you're the judicial branch, all you're doing is basically creating opinions, writing warrants, and you're doing all these legal paperwork, but you have no power. You have no authority to enforce it yourself. And in order to do that, you have to have did you call it the executor, the executive officer?
He's the executive officer of the court clerk.
And this is a similar setup as to Congress and the executive branch. The executive branch is the strong arm of Congress.
Exactly.
It's just a really amazing thought when you think about it, that the court has no power without the sheriff's department. The sheriff, the county sheriff, that is why the county sheriff is truly the law of the land, because he's the only one that can enforce the will of the judicial. And the congressional, the legislative.
So what about the state marshal?
State marshal or United States marshal?
Or U.S. marshal.
Well, U.S. marshal, they only have power in the District of Columbia and in the territories of the United States.
So why do all of the courts here have marshals in them?
Because they're district courts.
You mean the federal district courts?
Maybe that's what it was, because I used to work for the Orange County Superior Courts, and there were marshals all over there.
Superior courts are, I believe, those are federal districts, right? District courts?
Well, I don't know. If he's talking about a federal district court, then they're manned. Federal district courts are manned by the United States Marshals. If you happen to see a United States Marshal in a state court, then they're probably there because they are either picking up someone or delivering someone, usually picking up someone.
What I found interesting, though, is sort of the conclusion that we came to, which was, this means that if your municipal court or your municipal police department, which again is kind of the strong arm, that means that all the municipal police are also under the sheriff, and that if they are messing with you, technically, you could approach the sheriff and say, how do I word this? You are supporting the act of your underlings, basically. You are supporting the act of the courts. So if the courts are acting with in fraud, then technically the sheriff is responsible for that.
Yeah, well, this is the thing. Police chiefs are put into office by other politicians. Sheriffs are supposed to be elected by the people. Yeah. Big difference.
Yeah.
So all police chiefs, no matter what municipality it is, all they are is a security guard hired by that particular corporation. The sheriff is supposed to be elected by the people to protect the people's rights. That's his number one purpose. But here's the problem. In most places where there are sheriffs, there are no people. All there are is citizens. All there are is residents. The land itself is vacant. There are no people. So that sheriff only has one job to do, and that is to enforce the statutes, which is what needs to be enforced, and those foreigners running around call themselves United States citizens.
And that's interesting because I've heard, I haven't seen the proof yet, but I'm understanding that they are in talks right now. And one of the reasons, I guess, that our sheriff here is not one of the quote-unquote constitutional sheriffs is literally because he's the CEO of this, alternative, non-voted on police force that the sheriff went over to. And while he still acts and is the elected sheriff, he doesn't really do anything except monitor the courts, basically, as sheriff, and his deputies do that. So, I mean, he'll take care of his duties as the elected sheriff, but as you say, there's not much to do because the people aren't acting as men. They're all, and I guess. So I hear that the sheriff they're trying to get it to where the sheriff is appointed and not elected.
Well, the minute he becomes appointed, he's no longer a sheriff. He's something else.
Well, I think they're trying to change that. That's what I'm hearing. I haven't verified it, but someone is very concerned that I was talking to. I can't remember who it was, but it's interesting. So back to the mortgage, the deed of trust. Just for clarification purposes, why don't you walk people through what homeowners probably already know, but maybe many people don't. What is the process of obtaining a loan and obtaining the title for a home, and what is the difference between a deed of trust, and a title, and the loan application and that? Because I think we have to distinguish what it is that we're doing, because I think a lot of people might listen to this and say, well, that sounds like kind of like fraud. You're going to go in and you're going to cheat the bank of the money that it loaned you. But we have to consider the real devious truth is that the banks, by law, are not allowed to loan you their own money. They cannot loan you their deposits because those deposits are liabilities. You can't loan someone else a liability that you would owe to one of your customers.
Okay. So let's take it from the very, very beginning. I'm looking across the prairie there, and there's this huge piece of land that's vacant. Along comes a municipality called whatever, Stockton, whatever town you want to call it, and they say, well, we're incorporating this piece of land into our corporation known as the city of blah, blah, blah. And to sell this land for, and I'm using an example of a subdivision that I'm doing some work on, and we're going to sell each lot. We're going to divide it up into 20,000 homes, and each lot we're going to sell it to this developer for $17 a lot. What a deal, right, for the developer. He's getting each lot for $17. So in return, the developer is going to put in water, sewer, and then an electrical company is going to bring in electricity and phone and all that kind of stuff. And then he's going to begin to build homes on this lot. He's going to give each home an address. That address becomes a fictional location within that corporation known as the city of blah, blah, blah. Okay? Then that developer is going to set himself up so that he can sell those homes to residents. Okay? And that developer is going to get his money or his check that a bank is going to create out of whatever source, really is coming out of nowhere. They're just going to write him a check that he's going to deposit in another bank, and that money is going to continue to do whatever it's going to do. But anyway, I'm trying to keep it simple to just the progression of the thing. So
well, what is a resident when you say sell to residents? Because you're not a resident until you buy, right?
Correct. But as soon as you move into that home and you call that home your residence, well, now you're a resident of that residence.
But aren't you really a resident of the United States?
Well, yeah, all residencies are in the United States. They're in a territory of the United States, in a territory of the District of Columbia.
Right, and that's what a state is. So basically, the municipality is just part of the United States, incorporated within the United States. So you're a resident of... Yeah, I got it.
Yeah, so in this is the part that confuses people. Every corporation is, in fact, belonging to the United States, the District of Columbia. And whenever you get talked into incorporating your business, you basically just gave it up.
You've just volunteered and agreed to follow all tax law and everything else.
Yeah, and you gave up your business that you worked so hard to create. You just gave it to the United States.
Yep.
It's no longer yours. That's why they can tell you what you can do with it.
They can take it anytime they want to.
Yes. So anyway, so back to the example. This developer builds all these houses. Then they're going to sell them to people. And the benefit, okay, for the city, municipality, is that they are creating more residents for their municipality that are going to pay property tax. They're going to pay taxes on electricity, taxes on the water, taxes on their phone service, taxes on all these other things. And then they're going to pay taxes for registration, and they're going to pay all these tons of taxes. So they're creating customers for themselves. So it's a huge benefit for them. Then those people go and they try to get their home supposedly financed. So they sit down at closing. They bring with them $10,000, $20,000, which represents a good chunk of their hard labor. They put it down on the table as a deposit. The bank takes it, and then they give you in return a piece of paper, which is really a blank check, called a deed of trust and a note or a mortgage agreement. You sign it, and they take it back. And they say, okay, the house is yours. You now move into the house, and when you get home, you start reading the paperwork, and you go, wait a minute, this thing says that I'm a tenant. It doesn't even say that I'm the owner. What does this mean, a tenant? And then you start doing a little more research, and you come to find out that you, in fact, don't own anything. The house is not even yours. You're a tenant. You're renting it. You're there temporarily. So then you try to figure out, well, who really owns the house? Who has a control interest in there? And then the more you keep looking into it, the more you realize that the ones who really own it is the municipality and these banks. Okay? And they're pretending that they own it, but in fact, not a single man or woman has signed any of the paperwork. You're the only one who signed it. And at the end of the day, here you are signing over a note, maybe a deed of trust and a mortgage agreement.
Agreement, yes.
Okay, and then you're going to spend 20 or 30 years paying for it in spite of the fact that you signed over, in fact, a blank check. And this is the part that we're attempting to get hard evidence on, is that the deed of trust and the note are converted into legal tender. Okay? Now, before you even got to the closing for your house, you filled out an application for credit. When you filled out an application for credit, you received a letter, or someone called you telling you, hey, your credit has been approved. You've been approved for credit to buy the house. When they told you that you were approved for credit, it means that the credit was created for you. So if you're buying a $300,000 home, somebody created $300,000 credit for you. So you show up to the closing, the $300,000 to pay for your house is already there. Now you fill out and sign a deed of trust for $300,000 minus your deposit. And you also sign a mortgage agreement for $300,000 minus the deposit plus the interest, which is going to bring the whole amount to like $600 and some thousand dollars. So you've actually created somewhere around 4 times the amount, $1,200,000. And yet you're still paying for it. Now, I have sent paperwork to the banks, giving them 21 days to respond to the fact that we're under the belief, not belief, but belief with an F, that the note was converted into legal tender. And that's the only simple question that we're asking. And we're saying, we're giving you 21 days to respond and let us know that the note was in fact not converted into legal tender. If you do not respond, then we're assuming that the note was converted into legal tender and that the house is in fact paid for, and my payments to you in this mortgage is nothing more than a voluntary act to give you additional profits. Two banks, Bank of America was one of them, responded by saying, we will not contemplate that type of a question. We will not answer it. It's a very simple question. Yes or no? They will not answer it.
Well, now, I've never thought of that approach. Is not answering, what does that mean?
It's either refusal to exercise fiduciary duty, or it's fraud.
Or it's avoidance, basically.
Well, there's not much in between. There's all kinds of cases that say that basically a corporation does not have the option to not answer something that it's within its job description or whatever it is that it's supposed to be doing. Now, if the bank is involved with you in a supposedly monetary transaction, which, by the way, money is never exchanged when you buy a house, they have a fiduciary duty to answer your questions. They have to answer your question. And for the Bank of America to directly say, we are not going to answer that question, it's just very blatant on their part. I can't believe they actually said that. I laughed when they said that. But that's all evidence that can now be used against them in court. They cannot not answer that, And then I showed this gentleman earlier a deed of trust that I have here that has a stamp on the very last page after the signatures of the people who supposedly entered this agreement. And it says the order of without recourse, and it's got the name of the original supposed lender. Now, anything that you see that says payment to the order of, it means that somebody's getting paid something. And if you put pay to the order of on a piece of toilet paper and then you write an amount next to it, it just became a check.
Well, it's the same thing that's written on the back of a check.
Yes. It just became a check. And I have another fellow that I'm helping in on the back of his, I think it was the note or the deed of trust, it's actually got 3 stamps on it from 3 different companies saying pay to the order of.
Now, is that because it's been transferred?
That's what it appears, like it was cashed 3 different times.
Yeah. Now, one of the things you said that actually I found really interesting is that the original note, the agreement that was signed, cannot be altered. Once it's altered, it's no longer valid.
Well, it's no longer the original note. I mean, if you were the last one that signed the note, okay, no one can even put a little dot anywhere on it. If they put a little dot on it, they just changed it. So no one has the authority to touch it without your consent because they're actually changing the value of the note.
But then again, you can change it with only your own consent.
Well, because you're the only one that authorized it. Your signature is the authority.
I mean, this really does open up a lot of possibilities. Now, I have to say, reading from the Federal Reserve's money mechanics, it's very interesting when you start to understand, I think, the concept of how this money is created. And you said the most important word, of course, is credit. because most money in the system right now is simply a digital figure that's created out of. I mean, you could say it's created out of thin air, but I mean, it's a little more complicated than that. But it says, who creates money? Changes in the quantity of money may originate with actions of the Federal Reserve System, the central bank, depository institutions, principally commercial banks, or the public.
Okay, but you use the word money there, right?
The quantity of money.
The quantity of money. And money is something tangible. Something is something that you can hold, something that has value. That's the definition of money. Credit is not money. Credit is just credit. Huge difference.
Well, that's probably something we need to explore. Because the actual process of money creation takes place primarily in banks. So the actual process of money creation takes place primarily in banks. Checkable liabilities of banks are money. These liabilities are customers' accounts.
I'll go grab my Black's Law Dictionary and look those up as well.
Okay. Well, yeah, the Constitution says, a lot of people I think get confused by what the Constitution says, which is the only lawful money is gold and silver, and that Congress has the only thing that can create it. But that's not really. You can't be too literal about that, because Congress has the power to create the Federal Reserve, which it did, and give the power of money creation to the Federal Reserve, which it did. So, you can't just go look at the Constitution and say that money is only this and this. No, that just because the Constitution says something like that does not limit it to that. It just is limiting the specific branch or the specific congressional thing. It doesn't mean that can't change by legislation, unfortunately.
Well, but see, this is, and I mean, I'm still doing a lot more research on this thing, but from what I'm understanding, a lot of those legislative regulations or whatever that Congress creates to govern the transaction of quote unquote money and credit, it's only to happen from bank to bank, not from banks to people. Okay, and from bank to bank back to the United States. So it's basically for private transactions between the United States and its banks. Okay, and the way they extend these transactions is if you are acting as a U.S. employee, which, remember, the banks always want your Social Security number and they always want you to admit the United States citizen, then technically they are not violating any law because they are treating you as a U.S. employee, and they have the right to be in business with the United States and its entities.
Well, I think the most important point with this in dealing with credit, the point here, again, for people who think, well, wait a minute, it sounds like you're defrauding a contract or defrauding the bank, you have to realize that at the time of this loan, which, again, was based on the creation of credit, creation of digital money somehow, the bank did not ever loan any of its own money to you, the so-called borrower. So in other words, at the time that the loan is funded, the bank creates or receives the money from the Fed or whoever creates it, or it's created out of credit. I don't fully understand that. And then it is given to you or given to the actual owner of the home. And at that point, most importantly, the bank is at a zero balance. In other words, you don't owe the bank. The only reason that you owe the bank is because you're voluntarily signing an agreement that says you owe the bank principal and interest over an amortized amount of time that will eventually pay all kinds of, ass-kicking interest. But in truth, that is only an agreement, a contractual, a unilateral contract basically a one-person contract where you're agreeing to do this. So you're not defrauding the bank. The bank is defrauding you by not letting you understand that the bank never loaned you any of its own money, and therefore you don't owe the bank anything in the first place. The only reason you owe it is because you agree voluntarily to owe the bank, and that's the hardest thing to explain to people.
Well, and this is the thing is that people also confuse the term title, because they refer to it like to the title of their car, because they have a piece of paper that says certificate of title, and they think that somewhere in their paperwork, when they buy a house, they have this thing called a title that is the title for their house. Title has nothing to do with paperwork. Title means your interest in that property, your rights to that property. That's what title means.
And title.
When you have title to land, it means that you have the right to that land.
But we have to explain again. This is that tricky thing, because people don't understand, I think, the word right. A right is either positive or negative. It's either natural or political. So if it's a political right, again, it's basically a revocable privilege. If it's a natural right, then it's something that's inherent. It's not something that can necessarily be taken away. Likewise, a positive right as opposed to a negative right. A negative right is a natural right. A positive right is a political right, a privilege, basically, a revocable privilege. Everything in government, including titles and everything else, are revocable privilege. They're positive rights. And it is your right, folks, anyone that's listening, I can't stress this enough, it is your right to be taxed, it is your right to be punished, to be put in pain, to be exacted, in other words, extorted from. These are your rights as listed in title, I can't remember, but it's the Statement of Equal Rights. Go section 1981, I believe. I just can't remember the title. Go read that sucker, and you will understand what the definition of a right is when it comes to being a citizen or a person. The only real rights are as a natural man. So we're acting in this realm of artificiality here when we're talking about a title.
So let me expand a little bit on the deals with the when you buy a house. So when you buy a house, you enter into this agreement to pay back this loan that you are under the assumption that the bank gave up something for you to be able to get into this house. Okay, that's the whole transaction is based on an assumption that the bank gave up something of value in order for you to be able to enter into this house.
Now, just to be clear, the assumption of abeyance and agreeance in law is the basis of this entire system, including what we were talking about earlier with the consent. Basically, the whole system is prima facie in that it is an assumption of law, but is not actually law. It is an agreement between you and government that makes it a contractual obligation, basically.
Yeah, so you enter into this agreement based on the fact that the bank supposedly gave something of value. So
supposedly,
supposedly, but in fact, the only one that is really putting up anything of value as collateral is you, because the house is collateral. The house is for real. Okay, there's no one can doubt that there's a house there. So there's a real house there, okay, that holds real value. Then next to that house is this man or woman who is going to spend 20 or 30 years of hard work to pay for this note, for whatever that agreement is. So there is real labor now being traded for the privilege of being a tenant in that house. Okay, now let's go back to the bank. What did the bank, in fact, give up as value for any of these two things that are existing here, the house and your labor? All they did is enter a note into their books that says, Clint just borrowed $300,000.
Mm-hmm.
And now we're going to write a check based on this entry into our books and here's a check for $300,000 for Clint. All right, Clint.
Because we're allowed to, because the Federal Reserve says we're allowed to. Simple as that.
Would you guys like me to read these Black's Law definitions?
Go ahead.
All right, well, for mortgage, it's kind of interesting here, and a loud truck going by there, but it says, a mortgage is an interest in land created by a written instrument providing security for the performance of a duty or the payment of a debt. At common law, an estate created by a conveyance absolute in its form, but intended to secure performance of some act, such as the payment of money and the like, by the grantor or some other person, and to become void if the act is performed agreeably to the terms prescribed at the time of making such conveyance. The mortgage operates as a conveyance of the legal title to the mortgagee, but such title is subject to the defiance on payment of the debt or performance of the duty of the mortgage, or the mortgagor. And then a credit here, it says the ability of a business or person to borrow money or obtain goods on time, which is an interesting comment there, in consequence of the favorable opinion held by the particular lender as to solvency and reliability.
And this is, it's amazing that I can listen to that and actually make out what most of it is saying after years of looking into all these words. That's the kind of thing that you have to sit down and you really have to understand each word and what they mean. But it's basically what Burt was just saying in legal terms. But Burt was explaining that whole process just now. It's just a lot harder to understand in the Black's Law version.
Listen to this, though, also, Clint. It also says here under credit, time allowed to the buyer of goods by the seller in which to make payment for them. So it's also the time, the credit. The correlative of a debt, that is, a debt considered from the creditor's standpoint, or that which is incoming or due to one. Due to one, that's another interesting one. That which is due to a person as distinguished from debit, which is due by him, claim or cause of action for a specific sum of money. And then credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debt and defer its payments. Uniform Consumer Code, Section 13017. And then it's got interesting definitions here of a noun and a verb. Accounting as in accounting as a noun, an entry on the right side of an account. So here's credit. By definition, a noun. It's just the entry on the right side of an account.
Exactly. Isn't that funny?
And that's the foundation of how banks actually operate.
Right.
They operate on credit. They don't operate on real money.
The word duty is also very important because basically, if you have a right, then let's say Jan, as a natural right, if I have the right to refuse you entry onto my land, my natural God-given right, however you want to, verbalize that, then it is your duty, your natural duty, because every right creates a duty on everyone else, basically, and that's how common law basically works. Your duty is then to never trespass against me without my permission. So a right creates a duty, and in that, what we've done is we've gone from the natural realm into the political realm. And now, instead of having natural, do no harm to others or their property type of natural law and natural rights, we now have political or positive rights. So a negative right is to not have something done to you. In other words, it's your right to be absence of any force. Whereas a political or positive right, or anything in the Constitution, anything by government, these are all positive rights, which means that you are forced into an opposite duty.
Sure,
so,
and get this. Sorry to interrupt you here. Under duty in Black's Law, it says, a thing due, that which is due from a person, that which a person owes to another, an obligation to do a thing. a word or more extensive signification than debt.
Yeah, and it's very important because you're literally creating, instead of a respectful natural duty, you're actually creating one that's enforceable technically by law through the contractual obligation, instead of, which is how government operates. That is what force literally is in government. To get the protections of government and the entitlements, all the good stuff, you have to take the duties of all the bad stuff, which is taxation and extortion, pain and punishment and all this. So you're literally, by signing this agreement with the bank, you're creating a duty upon yourself to literally follow the word of that agreement. That
think of military duty. Think of military duty, Clint.
Absolutely. That's what we're saying. I mean,
yes.
So, and when Burt says that now, because you're the only one that's actually alive, first of all, you're the only signator to that agreement. Therefore, again, pulling back the veil of the matrix, you're the only person that can change that duty. And to change what your duty is, which has been forced upon you through fraud, you go in and you say, well, this contract, this unilateral agreement, this trust, this now says, per the only signatory, which is me, the alive person that's actually doing this, I have a zero balance. I will make zero payments every month, and I owe zero interest. Because you have already been paid, bank. You never loaned me any of your own money in the first place.
Mm-hmm. Okay, now here's another part to that equation. Now everybody knows that corporations love insurance, right? So why would you, if you're a big corporation, why would I enter into a business deal with Clint, even though, knowing that Clint has like a 350% chance that he's going to default on the loan? I might do that if I insure his loan.
Oh.
So that in case he defaults, I am covered.
And what is insurance?
Okay. So, if in fact the loan is defaulted and that bank got paid by an insurance company, is there a debt? No, there is no debt. But what happens is when they take you to foreclosure, which, by the way, the Rule 120 hearing, which is what anyone who's been in foreclosure is going to end up going into, is not an adversarial hearing. It's just simply a fact-establishing hearing. And the only fact that is going to be established is whether you defaulted on the duty that you guys very well defined or not.
Okay, and why is it so important that it's an adversarial court when you enter into a court? Why is it so important to be adversarial?
Because then you have a say-so. When it's not adversarial, you have no say-so.
So what you're saying is that you're basically going into court and just agreeing by being there. You just agree. No matter what you say, you're agreeing to the terms of the agreement that you signed, your duty. You're basically admitting to your duty. Nothing.
I have a friend that went through it, and he kept telling the guy there acting as judge, telling him, hey, look, I forgot what the bank was. This bank does not have standing here. They're not on the original note. They haven't proven that they have a liability. Basically, they haven't proven that they have a dog in this fight.
They have no proof of claim.
No proof of claim. And then the second part of this, get all intimidated because they have all these attorneys involved in the foreclosure. The attorneys are nothing more than collection agents. That's all they are. They're nothing more than that. They're a collecting agency trying to collect on apparent, quote-unquote, debt. In order for there to be a debt, there has to be a loss. And in order for there to be a loss, there has to be someone who lost it. So that someone who lost it needs to present to you a verified complaint, which means a real man or woman must sign some kind of a piece of paper saying that they were injured by you. And that's why they're there trying to take your house away.
And
attorneys will never provide that.
And that would mean that they're actually responsible for anything, any damages or any claims. In other words, they're taking on responsibility, which is what corporations never do.
Right. So the whole foreclosure deal is not necessarily based on a debt. It's not necessarily based on a loss. It's based on you not fulfilling the duty. And the most important question that needs to be asked in all these proceedings is, was the note paid to begin with? Because if the note was paid, there is no argument there. There's nothing to deal with. But that's why the Rule 120 hearing is not an adversarial hearing, because if it was, then you would have a chance to present evidence that could counteract what the collection agency is trying to establish. And if you read about the 120 hearing, you will see that it's not an adversarial hearing. So the only way you're going to get an adversarial hearing is to counterclaim the banks.
Now, we talked about this, we touched upon it in the last interview. We talked about this adversarialism, the fact that, you know, a lot of times when you're going into this administrative type of court, again, we're in the court of equity now, not the court of record, we don't have any power or authority as men. We are at the subject and will of the decision or opinion of the court. And, of course, the court is just following the rules of court procedure, essentially. So the fact that it's not adversarial, I just want to hit this home, basically means that you can stand up there and you can filibuster for hours and hours and hours. You can read off every law in the book, everything that applies to the case, but the judge does not have to take that into the record.
No, he doesn't have to abide by it. He doesn't have to do anything. And in fact, when you're in a 120 hearing, you're not even in a court. You might be in a building that looks like a court, but you're not in a court.
What's the definition of a court?
A place where there's an adversarial situation.
Well, there you go.
If there is no adversary, then what are you there? You're there with Casper, you know?
Yeah.
I mean, these are just points that are so huge.
I'm looking up court right now here, see what we have here in Black's Law. Go ahead, you guys can talk while I look for it.
Well, you know, I want to say, too, you know, you're saying that one of the most important questions is, was the note paid? Was the original, you know, was there ever a transaction where there's a liability, basically? And see, the whole mortgage crisis that happened, it wasn't a crisis at all. I mean, these people made buco bucks off this thing. I mean, we're talking, if you think about it, first of all, the loan is created without any money actually being lost from anybody. In other words, it's a credit. It's nothing. At the inception of the loan, the house it's purchased, the money is handed over to the developer or whatever, or whoever owns the house, but no one actually lost that money, so there's no liability necessarily. So what happens? Well, okay, I include in my as the bank, of course, I include in my agreement a little side note that says we have the positive right to sell your mortgage, your contract, your title, your deed to the next bank that comes along. It might be my bank. I might buy it from myself. Doesn't matter. Why would a bank want to do that? Why would a bank give up a sure thing like that? Well, guess what? As we said, the bank is at a zero balance. It is making nothing but the monthly payments that you have agreed to. So how, then, can a bank make off like a bandit in just 45 days? Well, it sells the loan. Okay, say you have a $400,000 loan. It might sell that loan, or that, what we're calling a loan, that agreement to pay, it might sell that for $200,000 to the next bank that comes along, or it might sell it to itself and create more money. Right? So now, this bank, for 45 days, maybe 60 days of work, creating the note, putting a little journal entry in there, doing all that, it has just created, out of thin air, $200,000 that it can now reuse, and now that loan document is with another bank. What's the next bank going to do? Well, It now has basically a $200,000 loss that it needs to recover. It's not going to be able to recover that until you do your duty of making payments to the new bank because you agree to it. So what's that bank going to do? It's going to sell the loan to the next bank or possibly to the bank that just sold it to them. You see, this is the scam, and it's going to sell it for $230,000. Then that's going to sell the next bank $260,000, and eventually, in planned obsolescence, as they manipulate the markets, create artificial scarcity and artificial value in homes, and decrease the value, someone, probably some bank that they're targeting to be reabsorbed into some other larger bank, that bank is going to buy the loan, and then the prices are going to shoot down. That bank's going to be stuck with...
You mean Washington Mutual?
Yeah, exactly. That bank is going to be stuck with a toxic asset, something that is less valuable than what it bought it for. And then the taxpayers come along, put all the money into the system, bail out the banks get subsumed by other larger banks, and the whole process starts over again. And we're in the middle of that process right now.
Okay, let me add another part to this mix. Okay, I just talked about the insurance. Well, we've heard of the bailouts. Okay, all these banks got paid billions, trillions of dollars. Was your loan included in that bailout? Was it paid by the bailout? Well, that's a question that the bank should answer for you.
So you're saying that you might be sitting on a loan, or I should say an agreement, that was already defaulted and paid.
Yes.
I hadn't even thought of that, Burt.
Mm-hmm.
Yeah, that's pretty fantastic. Yeah, that never.
But if you don't ask the question, they don't have to answer it, because remember, they're only taking you to court not because the note was paid, not because they had a loss, but because you failed on your duty. To make the payment.
Which you agreed to and signed your signature, and until you change that agreement, you were bound by it.
Yes.
Yeah, isn't it? This is the way the government basically works. And when I say government, every bank out there is a member of government. Every corporation, as Burt said, is a member of government. They follow the rules of government. So Federal Reserve is just following the rules, and it's allowed to make its own rules. And then this is how this current... when we say the word economy, I always laugh at people who call themselves economists, because most of them have never even heard of the CAFR. But this is the economy. This is the most fraudulent system you can imagine, and it literally is the economy. The whole economy is based on servicing debt, servicing toxic toxic assets, toxic debt.
Okay, let me add a point to that. The way I see the so-called economy, and everything Clint is saying is correct, but what it really is, the economy, what it really is a transfer of real valuable assets for something that's worthless. That's what the economy is.
Yeah, absolutely.
It's just a transfer of real wealth for something that mirrors the real wealth, which is either credit or dollars, which are both nothing. Their toilet paper has more value than those things.
Yeah, I mean, it's technically the dollar is really no different than a gold chain. It's just bling. You can own all these things. They're really. I wouldn't say they're worthless because they can buy things, but what Burt, what he's saying is that government is basically transferring all of the real assets, all the real estate, all of the stocks, all these currencies, foreign currencies, all the gold, everything is being transferred into government and its investment held corporations, and the people are being left with nothing but toxic debt, dollars, which are IOUs, basically.
Yes. So let me read this to you because this is really good here. This is the definition of court, and it first starts off with a definition of a space which is uncovered but which may be partly or wholly enclosed by buildings or walls when used in connection with a street indicates short street, blind alley, or open space like a short street enclosed by dwellings or other buildings facing thereon. A legislative assembly, parliament, is called in the old books a court of the king. Nobility and commons assembled. This means of the word has also been retained, or this meaning of the word has also been retained in the titles of some deliberative bodies, such as in the General Court of Massachusetts, i.e. the legislator. The person and suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. The English government is spoken of in diplomacy as the court of St. James, because of the palace of St. James is the official palace. And then this is where it gets real good here. An organ of the government belonging to the judicial department whose function is the application of laws to controversies brought before it and the public administration of justice. The presence of a sufficient number of the members of such a body regularly convened in an authorized place at the appointed time, engaged in the full and regular performance of its functions. A body of the government to which the administration of justice is delegated. A body organized to administer justice and including both judge and jury. And here's where it gets really good. An incorporeal political being composed of one or more judges who sit at fixed times and places, attended by proper officers pursuant to lawful authority for the administration of justice. So right here they admit it's an incorporeal being.
Meaning it's not corporeal, meaning it's not alive, it's artificial. And the officers
but they even admit that it's a being, so it's...
Oh, yeah. Oh, no, the whole thing is, it is the language of the Law Society. It's really...
Well, and legally speaking, the judges, the court, is actually a political body.
Mm-hmm.
So it's part of the political system. So what kind of justice can you expect to go to court against a corporation that was created by the body politic and then now is being supposedly refereed by a member of the same body politic who has an interest in both parties? It makes no sense.
You know what's crazy, Jan? Just occurred to me. You're the one that first kind of turned me on to. I can't remember the word for it, but the study of words, basically, where you say that government literally means control of the mind.
Right.
Right. Well, if you think about it, what you just read. You used the word administrative. It administrates the justice. Well, that's what court is. It's administrative. It's administering the law. So it is literally, giving the law. It's giving its opinion. But again, how can you enforce that opinion, that administration of law, unless you have in your government, in your mind control, you must also have enforcement. Law being created by the courts, enforcement. That's where the sheriff, again, comes in. So what's enforcement? But, forcing the mind to follow the mind control of government. It's actually a really... Again, it's like viewing the Matrix for what it really is.
And when you and again, when you change that ending to a suffix, suddenly all of this understanding disappears, right? And that's what I find the most interesting whenever philologists, etc., contact me and force it, which they did last time as well. And there was an interesting debate there on the Gnostic Media website from the last post, and I think it concluded pretty well in our favor there. But it's government and mind control and all of this, and the secretary, like a secretary of state or whatever. The word secretary comes from the word secret and sacred. And then we have, as I mentioned last time, and Burt didn't think it pertained, but I really think it does, because you have the magistrate or the magi who writes these laws down for everyone to follow in the first place. So somebody writes these codes and things down that everybody then goes and follows. Who by magic they give their consent or their autonomy over to just follow this stuff. And then we get down into, magic and spelling, and the word abracadabra comes from the word abecedarian, one who studies their ABCs, right? So abracadabra is somebody who studies the ABCs, and they cast spells or laws. The magistrate is exactly someone who essentially does this.
Okay,
now, Burt,
but see, let me jump in real quick. But see, all that stuff that you're saying is completely correct, and in fact, Clint and I were discussing one word, which is the word illicit, which is one of my favorite words.
That's what I was going to ask you.
Which in all government transactions, they actually are eliciting information from you. And if you look at the root meaning of illicit, means obtaining something through trickery and magic. Okay, so they're obtaining information or consent from you through trickery and magic. And what we're trying to teach people is that you do not have to go to court and be in a trickery and magic court. You can convert that court to a real court of the people. But in order to do that, you must be in the right type of court, with the right type of court clerk, with the right type of magistrate. You don't want to be in a magistrate like the one you just described. You don't want that kind of a magistrate. You want a different type of magistrate. You want one magistrate that is a true referee. And you don't want to be in court under their law. Because first of all, you don't understand it. So how can you be under their law? So you have to bring in your law. And I think I did send to you, Clint, the one part from the Colorado statutes that says that you have the right to bring in the written and unwritten common law to court. How do you bring in an unwritten law?
Well, that's a good question.
Okay, so you have the right to bring in even a law that is not written. Okay, you have that right, but if we don't exercise those rights...
So what does it do? Does it fall back to simple common law?
Yeah, you can bring in 10
law,
people.
I should say. I meant natural law.
Well, you can bring in witnesses that say, yes, this man here honors a law which has been practiced for blah, blah, blah years, and the law says this, but it hasn't been written. Those witnesses become your law. Your practice in whatever it is that you've been doing becomes the law. The tradition becomes the law. It doesn't have to, law does not have to be written. It just has to be understood and comprehended. Now,
and we gotta say again that understand is a very important word, because when you understand something, it really means that you accept it as positive. You accept it as basically a right or a duty. Mm-hmm. So to understand is to stand under that authority or that law. So if someone, a judge especially, ever asks you, or a cop, when he reads you your so-called rights, if you understand, the answer is almost always going to be no, unless it's something that you actually do understand. In other words, you want to be your right. But if a cop says that your right is that I'm going to babble everything that you say right now, and it may or may not be used against you in court, I'm certainly not going to agree to that. I'm not going to say that, yes, I understand my right, because I don't. I don't understand that. I don't stand under the right that you just gave me. Get out of my face.
Yeah, now let me give you a quick example of the unwritten law, okay? Because I know this is a hard concept to understand. But let's say, Jan, that you have a 80 acres, okay, 40 acres or whatever. And in the one corner, the 1 acre, way in the corner of your lot, people take a shortcut to get to the grocery store by taking a shortcut through your land, okay? This has been going on for 20 years. You never opposed to it. So guess what? It just became an unwritten law that is now a highway. And all you need is witnesses to prove that they've been using that highway for X number of years, and it's a law.
Without damaging to the person or property.
Right. But that is an example of an unwritten law. It's not written anywhere, but it's a law.
It does say here that when you understand, you to know, to apprehend the meaning, to appreciate, understanding the nature, effect, and act, and then to have full and clear knowledge of, to comprehend, thus to invalidate, a deed on the ground that the grantor did not understand the nature of the act, the grantor must be incapable of comprehending that the effect of the act would divest him of the title to the land set forth in the deed. As used in connection with the execution of wills and other instruments, the term includes the realization of the practical effects and consequences of the proposed act.
Yeah, very well said. Now, let me say this about fraud. Fraud begins when you discover it. So if you were involved in a transaction with deeds or titles or whatever, and you just realize that you actually were defrauded, it could be the day before you make your final payment. It still doesn't change it. It's still fraud. But you have to bring it out.
I think a good example of that is the word conspiracy, because conspiracy is one of those words that is a legal term as opposed to, I mean, let's take, how about God? Or some amoeba on the bottom of the ocean that no one's ever seen, touched, or felt, or categorized scientifically. The question is, does that amoeba exist despite your belief in it, right? Well, of course, the amoeba exists, even though no one's ever seen it. God exists or doesn't exist despite people's belief. If he exists, he doesn't give a crap whether you believe in him or not. Like, the difference between that and when you pervert the natural world and you go into the legal world, now you have a case, instead of something being, alive despite belief, now you have something where, okay, well, a conspiracy does not exist unless it is seen and proven in a court of law. So people can act as much as they want together, a plan between two or more people, which is happening, of course, in government all across the board, but until the conspiracy is recognized as such, it doesn't exist. Period. End of story.
Mm-hmm. Yeah. Okay, I'd like to, I guess we're going to have to wrap this up. We've been going for a while. But this is another project that I'm trying to get on, because Clint brought up the thing about the sheriff, and the sheriff is as far as I'm concerned, is the most important officer on your land, because obviously he's the one who can enforce anything that happens in the court. So I started this with another fellow, and I'm going to make it available to everybody, which is basically a notice to your sheriff, and it's to put him on notice to make it clear to you whether he's acting strictly as a statutory officer or if he is acting as a common law officer, and if he is admitting or denying that he in fact was elected into office by real men and women. That's a pretty difficult thing for him to answer, because if he says he's acting as strictly a statutory officer, then he's denying the fact that he was elected by real men and women. That means that he's admitting that he was only elected by persons, legal persons. And he cannot deny the fact that he was elected by real men or women, because then now he's acting fraudulently. And you can accuse him of fraud. So it's a really difficult position to put him in. And I would like everyone all over the place to send a notice of this type to the sheriff. And depending on his answer, then that's going to determine the action of the community, which is basically to sue him and kick him out of office for lying to the people about his elected office.
Again, we have all these ideas and we have this concept of things. What we don't have is the backing and the support and I know there's got to be someone out there that's rolling in dough that wants to do something to help get stuff like this organized, but until that person or group steps up to do it, then we can talk till we're blue in the face. We can spend all our time in this artificial construct of media and radio and all that, but until we actually start really getting people to literally enter these types of letters and demands and all this stuff, we really have no power. and I can't stress this enough, is that if we're going to get organized, I think this is probably, in my personal opinion, take that for what it's worth, this is the way in which we should be organized, because, again, our power as people, both in a group and individually, is absolutely dependent on each other and each other's support and protection of each other's, natural rights.
Yes.
I think that until we get some kind of, organized thing going in this respect, again, an organization that you don't join, but that you are a part of, that you are individually responsible for your own actions while still being part of a group.
Yeah, the revolution is moving, and the way I see it is it's a silent revolution, and people like you, people like Jan, you guys are fueling the revolution, and this is a different type of revolution. It's not a revolution where people go out there and actually take pitchforks and fire and burn things down or get violent. It's a revolution of knowledge, because as people learn to turn these courts to do what they're actually supposed to do, that's the revolution that we need right now, and it's a revolution of knowledge. I always say we suffer from a very curable disease, and that's ignorance. We can cure it with just a little education and a little practice.
It's an interesting concept because, again, if you take away the power of the court, you also take away the power of enforcing what the court creates. And so it's if you upset one of these branches, if you will, one of these organizational constructs that create such tyranny, the others pretty much have to fall into line, because without a warrant the sheriff can't act, without the court's permission, basically the sheriff can't act, and likewise without the sheriff the court is worthless.
Yes, and if you have a court clerk that actually does her job, she will not be moving your court cases to a judge. She will actually move them to the proper magistrate. So if you have these officials actually doing their job like they're supposed to, and these people are your neighbors, they're your sisters, they're your cousin, they're your husband. This is everybody's family. But for some reason, when they enter these jobs, they forget that they're people, and they become a robot.
It's sort of like that. What's it called? Stockholm syndrome. You become part of the enemy, part of the problem, even when it harms you.
Yeah. So we can fix all this. And my whole approach is one man, one woman at a time. And I just mailed off today 2 cases that are of my own personally. One case involves the bank actually taking money out of my account for the Department of Revenue of Colorado. Luckily, it wasn't much money. It was only a couple $100, but they took a couple $100 from me, and I'm like, all right, now I have a good case to go after.
And that's the difference. You get confident, and you're like, all right, screw with me. Come on, I'm looking for a cop to pull me over.
So I served them all kinds of notices, and I have all the evidence that I need now that I gathered, and I just filed my suit today. It went in the mail, and it went addressed to the court of record. So now I'm interested to see who's gonna sign for it, because I just sent that certified mail, and it was addressed to the court of record. So let's see who's gonna sign it, and I'm telling them everything that they have to do. And then the other case is involving property that actually just simply put a claim on that it looked like it was abandoned. And this is against Mellon Bank, $23 trillion bank. And they haven't been able to sell this one property for almost 2 years now because I put a claim on it, which anybody has a right to do. It looked like it was abandoned to me. I put a claim on it. I demanded to know who's the man or woman that this belongs to so that I can withdraw my claim. No one stepped forward, so I'm claiming it as mine.
And that's important because it's a corporation that technically can't, quote unquote, own the land. It's because there's no man. There's no
right.
So there's no real signature. The important thing about that, I think, is make sure that you're going over to that land and just throw a few dollars, for a few $100 if you can, and plant some flowers, mow the grass, pick up any trash. Make sure that you are showing that you are improving the land, and in your conveyance of that land to yourself, because basically you're conveying it from the void of non-ownership into the ownership of yourself, of a man.
Mm-hmm.
Make sure that you are showing proof that you are improving the land as you're trying to convey it. That's the only thing I'll say.
Yeah, actually, I'm going to go and turn the electricity on in my name. That's going to be the first. I'm not going to move into it until a court says that it's mine. But anyway, that's one of the cases that I'm doing. I'm also preparing another case, of course, against my TSA incident against the cops for incarcerating me without my consent. And then I have another case that I'm preparing against the people who run a toll highway here in Colorado. Because I've already told them I'm making use of the highway. You have no right to try to charge me for using an open highway. I have no agreement with you. Yeah, so all these cases of my own, I'm probably going to have like 6 of them in here pretty soon. But that's me just putting in probably 6 cases by myself. And my belief is if every single man or woman out there files just one case in his lifetime, just one, we will change the system.
I think it's important to say what Burt is doing is not... most people think of this whole system, the court system, as a defensive mechanism that we're always trying to defend ourselves. And in a way, that's true. You're always defending your rights, no matter what you do in life. But really what Burt's doing is going on the offensive. And not enough people realize that you can use the courts offensively. In other words, for your own benefit, to force certain things to happen for you. You don't have to take someone to court for monetary purposes. That's not really what court was designed for in the first place. You can literally, again, he's trying to convey land. And the truth is, you may never have to step foot in a court. You can do all this through the mail, get these default judgments. It's time, again, for people to literally realize that their power is within themselves, and that to draw back that artificial construct, that matrix, you're going to have to actually start taking action. And so I hope this helped. I do want to say one other thing on Burt's behalf, because we're always saying that talking about these things is one thing, doing these actions is another, and if you're going to do them, you better darn well know what you're doing, and for that, of course, you could contact people like Burt. But I will say this: the thing that Burt is doing, and it's something that I recommended, and fortunately, he was already having his clients, if you want to call them that, do. When you're doing this, you always want to show good faith. You always want to be the most upstanding citizen or man that you can be. And so when you're doing this with the mortgage thing, you have absolutely every right. If you suspect that your mortgage, your agreement is fraud, you have absolutely every right to pursue that to whatever end that comes from it. In the meantime, though, I don't think anybody, including Burt, would recommend that you stop making payments. What you should do is send a letter of whatever you call it, Burt, I don't know, stating, a letter of fact, stating that you are going to now put your house payments that are required from your agreement into a
escrow account.
Escrow account, thank you very much. Because now you're showing good faith that if the bank can prove it has a proof of claim, that it has a liability, and that you owe a debt, then those payments will eventually go to the bank. But right now, they're going to sit in escrow. I don't care for how long it takes until your proof of claim is there. If the escrow account is never tapped, if the proof of claim never happens from the bank, they have no recourse to take that money. They have to prove their claim as required by your offensive thing that you're doing in the mail. So you literally have that money sitting there. You basically can call it a savings account. If you're wrong, if the bank can prove its claim, then guess what? You're not losing anything. You're not in trouble. You've made your payments as an upstanding individual, and there can be no legal action against you because you've legally done something or lawfully done something by putting it in escrow. You always cover your ass is the point.
Exactly.
The point. And you're not trying to defraud anybody, and that's the real point I want to make. You're only trying to seek remedy and justice.
Yes. Now, this is the last thing that I'm going to say, and this is relative to the last podcast that we did. Excuse me, because Jan was talking about divorce, and this I didn't touch on this last time, Jan. That is this: you go to divorce court, okay? Would it make any sense for you to go to divorce court and have your wife's twin sister be the judge? It would not. Would it make any sense to have one of her family members be the judge? It wouldn't make any sense. But in fact, when you go to court, the judge who represents the state, who is in fact a third party to your marriage, is there to make decisions on your marriage. What kind of a fair hearing are you going to get?
So the party that stands to profit the most from your union, your contractual union, is the one deciding the fate of that union, that contract.
Exactly.
That's a good point.
It makes no sense. So therefore, you would want someone up there acting as a mediator who is not related to the state, because the state, I mean, Clint did a beautiful blog about that, where the state is in fact a third party to your marriage. So it is a party in interest in your marriage. Therefore, he cannot participate in any decisions to dissolve your marriage. There's a conflict of interest. You see that?
Interesting. Yeah.
Yeah. So that goes for anyone out there that's involved in divorce proceedings. Don't have a state employee decide the fate of your marriage and that of your children and your assets.
What about for people who already have? What do you do then?
Who have gone past that?
Right, who have already gone through the divorce.
Well, then you can just try to mitigate the damage.
Well, what about for like child custody? How would you go in and change that?
Well, that is always a living thing, and that's one thing that people don't realize. The child himself is a living, ever-changing situation. Whatever agreement was created back when the child was, let's say, 5 years old, now the child is 7 years old. This is a whole different scenario. This is now a 7-year-old child compared to a 5-year-old. The needs of that child change daily. So you can go back at any time and change any arrangement related to children. It's never a permanent thing. It cannot be a permanent thing because the child is not
in front of the. And you do that with the court clerk and the court of record, and not in front of a judge.
Correct. You would present it to the court of record and demand that she moves this matter before a party that is not a party to the matter, to the problem. Because I'm assuming you're doing all this legally,
or an employee of the state.
Yeah. And I mean, there is another step that I ask people to do, and I've talked to Clint about this, and that is the putting a claim on your children, so that you become the sovereign state of the children, not the state. So you become the sovereign over the child, not the state. And that's another step that I would recommend people do. I definitely filed one, and anyone who ever tries to come and try to act like they're going to be sovereign over my children, they're going to have to step over my dead body first. And
that is your right.
And we should probably do a whole show just on that subject.
Yeah, we could, because Clint, it's an expert on that one, because he pulled up all kinds of cases about the state.
In fact, Jan, I'm going to send you that. It's basically just a bunch of different cases, case law, in other words.
Sure.
I'm going to send you that. It's called "Do You Own Your Children?" It's just on my blog, and I'm going to send you my chemtrail thing, and maybe you could post that up too for this interview.
Sure, send it all.
Yeah,
but people really need to read this, because when you see that the state literally claims ownership of your child over you, that you're just basically the caretakers of state property. That is
you're the nanny.
Yeah, so essentially you just go in and you file a claim that you're the sovereign, and then that's it, because then they don't have anybody who can come and counter that.
Well, yeah, you give the state 21 days to rebut it. If they don't rebut it, then your claim stands.
Yeah, because you're basically asking for another man or female to come up with the documentation that they are the true, parents, or the true, I guess if you want to use the word, owners. But since the state is not alive, and you are, how can the state possibly claim to be the parent? It just can't. Mm-hmm. There's nothing alive.
What about divorced parents? Would you have to include the ex in that?
You would serve the ex with your claim and give your ex a chance to respond.
This is the hard part, I think, for most people, is mutual respect. You might hate your ex, but you have to always remember what we said earlier. Always enter in good standing, always offer equal treatment and equal respect to all parties involved. The only parties involved technically should be you and your ex. The state, again, you're trying to avoid the decision of the state as its opinion, because its opinion is that it owns your child as a piece of property, basically. So you always, that's I know that sounds difficult, because I know some people would like to strangle their exes, but always act in accordance with God's law or natural law, which is to do no harm to others or their property, and to always treat each other as you would want to be treated. And that's, that you follow that, you're going to do well in life, as far as I'm concerned.
Exactly. Well, good job.
Good show, gentlemen.
Yeah,
I think people are going to be pretty blown away from that one.
Well, I hope so. I mean, geez, it's something's got to blow them away.
Well, wait till they see what Joe Atwell and I have up our sleeves. We've got a new article that we've been working on for the last couple of weeks on, let me just give you the title. It's Manufacturing the Deadhead, a product of social engineering.
Beautiful. That's one of the subjects that I really want to delve into and just haven't gotten around to. And I love the research by what's his name, about the military children. Yeah.
Oh, who?
Dave
McGowan.
Yes.
Oh, he was supposed. Speaking of him, he was supposed to be on the show last week, and he went MIA. I never heard from him.
Yeah. It's a shame, because that's a fascinating piece of research there.
Yeah, I've been looking to have him on the show for years, and he finally agreed to come on, and then it was interview time, and called him, emailed him, everything, and I still haven't heard back from him. I've sent him a few messages since, and still nothing.
Well, and I guess the most important concept is just remember, and this is why I say the power is in the individual. That most of these movements and these moments of time that seem that there's a revolution, there really isn't. That it's all a planned and very staged change in things. And until we start realizing that we can't be part of that group, that the group mentality is the whole thing that's wrong with everything, I think that's the point where we're going to be suddenly feel like we're people again, free. I don't know.
Absolutely. In fact, just when you mentioned that, it reminded me of this guy yesterday on Facebook. He sends me this thing for some freedom group or whatever. I don't remember the name of it. And I just said, I'm not interested. And he said, what, you don't care about freedom?
Well, here's what you tell him. You take your Black's Law. I don't know if it's in Black's Law as good as it is in Bouvier's. The reason I like Bouvier's Law Dictionary, it's 1856, and it was actually accepted into the record of the Congress and the Senate, I believe, as the official law dictionary. And the reason I like it so much is because it actually has a lot of eugenics concepts in there. It defines what an imbecile and an idiot is, and literally it is the most honest dictionary I think I've ever found, as opposed to Black's, which is a little more subdued. But this dictionary really gives you a look into how those folks were thinking back then. So I usually, first place I'll look is Bouvier's before I go to Black's. And it is online as well. Bouvier's Law Dictionary, 1856. Yeah, it's pretty fascinating because you really can get a lot more out of that. And again, they say that it's the closest thing to probably what the founders of the country were also thinking at the time. Because again, all men being created equal, stated by a bunch of slave owners, doesn't really jive with me. So I think it's more accurate in that way, and I enjoy some of those old ways of thinking that are still around.
I've got an 1856 copy of Webster's as well. That I enjoy reading as well.
Yeah, you really need to go to as many sources as possible when you're looking up these legal words, and if they don't agree with each other, you really got to start questioning. And I know Black's has been changed with all its additions to detrimental to actually understanding the real concept of some of these words. And I like to say, man, if you don't know the meaning of your words mean absolutely nothing. Absolutely nothing to government. That's why I say in the beginning, you can call, you can protest, you can send a letter, but if it's not in the proper legal terminology and if it's not properly done, it means absolutely nothing. It is silence. It is rhetoric without reason. It means nothing to government. Government is artificial. You must talk to it as an artificial being. Simple as that. So, hey, Burt, I want to thank you again. You and Jan for hosting.
Likewise.
It's been fantastic.
Well, thank you, gentlemen.
Have a good night. It's been a pleasure.
We'll talk soon again.
Let's do a show on what was the topic again?
On children in the courts.
Oh, yeah. And taking ownership back or sovereignty back.
Mm-hmm.
All right, guys. Take care.
All right. Good night.
Good night.